Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Felicia Lynn. Today, we'll be speaking with David Radofsky about the prospect of civil rights under the Trump administration. David is one of the nation's leading civil rights and criminal defense attorneys, and he is a senior fellow here at Penn Law. Thank you for joining us. Well, to begin with, why don't you tell us a little bit about, in your view, what are the key civil rights challenges that our country faces today?
Yeah, there are several, and it's interesting to me. I think many of them are focused on the criminal justice system. Issues of mass incarceration, issues of fairness in the system, and equity in funding with prosecutors and defense lawyers. So a lot of what has been addressed in the last 8 years deals with race issues in the criminal justice system, obviously police, community contacts. Those range of issues, I think, are the forefront of a civil rights agenda. Not to say that there are very important ones. Civil rights in terms of voting is very critical. Looking ahead, civil rights enforcement in housing, in education and employment are still key areas. But if I had to pick out the one area in which I think more focus has been given and we're seeing more problems, it's the criminal justice, policing, prison area.
And how do you think that's going to map on with this new Department of Justice, right? We know now that Jeff Sessions is going to be nominated to be our next Attorney General. What do you think that means in terms of his support for those issues? And what do you think a Sessions Department of Justice is going to prioritize?
I think, unfortunately, the progress that we've seen in the past 4 to 8 years on some of these issues, and it's been minimal progress. Let me just talk, for example, about mass incarceration. A huge problem, and one in which the right and the left have tended to agree on in the last 4 or 5 years for different reasons. Conservatives don't like the amount of money we're spending on prisons. We incarcerate more people per capita than any other country in the world, currently 2.2 million. And so a lot of attention has been paid on that. A number of states have done very well in reducing their prison populations, the federal government a little bit, but at least some progress. At least we've kind of capped the numbers. They're going down a little bit. And they look like a good opportunity really to make some bolder moves in terms of mass incarceration. Just this past year, the Senate had a bill before it to do that in terms of reducing mandatory sentences and changing the sentencing structure for the federal system. Bipartisan support in the House and the Senate. It didn't go through, and partly the reason it didn't go through is that Jeff Sessions was against it. He was one of the few senators who was still saying the war on crime and mass incarceration works. Do we have too many people in jail? No. And he was refusing to go along with that, was able to hold up that legislation. So that's a very poor sign, I think, of where the Department of Justice will be on that issue in the next 4 years. Attorney General Holder pushed that. Attorney General Lynch pushed it. The president pushed it. And as I say, some bipartisan support on that. Newt Gingrich agreed completely with Attorney General Holder. So it wasn't even a left-right issue. So on that issue, I'm not optimistic. I think some of the progress we've seen in terms of policing issues, community policing, reforming police departments, thinking about deadly force and use of force. Again, minimal progress in some ways, but at least discussions going on, a number of departments engaging in new practices. That's not going to be a priority for this Justice Department. President Trump ran on a kind of law and order, right, campaign, and I don't think he's going to be one that's going to be spending a lot of time, or the Department of Justice, on those issues. And just as another example of that, one of the most effective offices in the Department of Justice for the past 8 years has been what we call the Special Litigation Division, which is a group of civil rights lawyers who investigate complaints about large-scale systemic problems in police departments and prisons. And they've been successful in reaching consent decrees with some 15 or 20 police departments, prison systems, juvenile justice systems. Very forward-looking consent decrees incorporating best practices that has really created some change in some of the most dysfunctional police departments in the United States. When President Bush was president, just before President Obama, for those 8 years, that office was virtually shut down and was open in name only. They did very little. And I would think in a Sessions Trump Department of Justice, that division is going to be very, very poorly handicapped. So on the criminal justice front, mass incarceration, policing issues, community policing, on those issues, I think we're going to have to start a rearguard fight to maintain what we have, much less to continue that momentum.
Those consent decrees that you talk about for our audience that are not lawyers, those are court-supervised agreements to remedy problems that generally have been highlighted during litigation, right? Are those the kinds of decrees that can then unilaterally one party can pull out of, or will those still be enforced because they're still in part and parcel of an ongoing litigation?
Unilaterally, the United States can't pull out of those, but what they can do is, these decrees, you're right, these are agreements between, let's say, I'll use one example, City of New Orleans and the Department of Justice, 100-page consent decree, kind of reforming that police department, training, supervision, discipline, use of force issues, stop and frisk issues, racial disparity issues, a lot of best practices built into that to bring that police force into the 21st century. The power the government has in that situation is that if the department doesn't do it, they can be held in contempt. That's an enforceable judgment in that case. If the United States doesn't go in and enforce it, the message is out there. Sure. You could walk away from this consent decree, and there's nobody else privately who can go in. There are private lawsuits. We've done litigation in Philadelphia around stop and frisk. The litigation in New York City over stop and frisk was privately done, but we don't have the resources that the federal government has, and losing them as a partner in this very important fight would be a serious loss.
I'd like to get us back to that, the issue we started with, which was police accountability, and certainly the underlying concerns about racism and police accountability has come up many times in the past few years. I wonder if you think that what President-elect Trump's approach will be. Will it just be to stop moving forward, or do you think that there will actually be policies that actively take some of that progress, and as you say, minimal, but some of that progress back?
Yeah, a little hard to predict. One would hope that it doesn't become a completely negative campaign and saying give police more power and don't worry about it and hands off and nobody sue them and we'll just live with what they do because crime is too serious a problem. I don't think that will happen, but it's certainly a risk. I think the real danger is the progress that we've made. So even during the debates, when Hillary Clinton talked about implicit bias, and not just a police problem, a problem that most people have, and Mike Pence came back and said, "Well, you're stigmatizing everybody as racist, right?" Not even to understand on that level how implicit bias works and how that may contribute to some of the more grievous situations we've seen in policing, really is a misunderstanding of our system. And if that's a signal of where things are going, that's a danger point.
So what are some things that states or municipalities could do if they disagree with Trump's approach? I'm thinking now about how some municipalities have reaffirmed their commitment to being sanctuary cities in light of immigration discussions. Is there some kind of equivalent for civil rights?
There is. And certainly cities, to the extent, let's take Philadelphia, for example. A city that I think has moved forward both because of some leadership in the city, which has nothing to do with what the federal government was doing, partly because at one point they called the federal government in to help them with use of force policies, and that's actually contributed to a reduction in the use of deadly force enforced by the Philadelphia police. Partly a result of private litigation. We've got stop and frisk litigation that's led this year actually to a 30% reduction in the number of stops of civilians in Philadelphia. So, and so that was largely done without the federal government really intervening. So cities that are progressive and want to move ahead on these issues, they're going to be able to. Although when you raise the issue, for example, of sanctuary cities, that's a whole other problem. Philadelphia, I think the Mayor Kenny is very strong on that. A number of other cities are as well. But they run the risk of losing federal funding. And that could be a very heavy blow to, a lot of cities that have budget problems. So we don't know how that's going to work out yet. So some things they can continue to do and will continue to do. There'll be some prices to pay. But what we're really worried about are those places, places like Ferguson, right? Places like New Orleans, places like Puerto Rico, that literally had dysfunctional police departments, which were engaged in daily violations, much more than you see in other places, where there's not the political will or power to change it. That's where the federal government has a huge responsibility. And the danger is that they'll step away from it. Same as we've seen in voting rights, right? So the same thing we've seen after the Shelby decision, where the Justice Department used to enforce voting rights provisions. You take away that power there because they said the statute was unconstitutional. It makes a difference in everyday lives. Mm-hmm.
So one of the biggest issues that was raised during the election cycle was that this new president would have the power likely to nominate at least one, maybe more Supreme Court justices. How will those nominations trickle down and impact to civil rights broadly, but also just criminal justice reform? How will prosecutors and criminal defense attorneys, what are they looking for when they see new nominations to the Supreme Court?
Well, we know it's going to be conservative. We can look at his list of 21 judges, all of whom are on the very conservative side. On the other hand, there are conservatives and conservatives. Sure. Even Justice Scalia, on some criminal justice issues was actually, quote, more liberal, right, than some of the liberals on the bench. So a little bit unpredictable. I have a feeling some of these justices are going to be more predictable from the conservative side. People like to say, well, you never quite know. You appoint a conservative and he turns out to be liberal. Look at Earl Warren. But that's a one-in-the-century kind of phenomenon. Generally, you get what you think you're going to get. So I would say two things. On the criminal justice side, again, he needs more than one appointment to change this court. Even if he has a conservative come in and replaces a conservative, it doesn't change the balance that much. Another appointment could make a stark difference for sure. Capital punishment issues, I think, on procedural fairness in the system. The conservatives tend to think less about that as an important aspect. But more important than that, I think, is this access to the courts question. There, the right is really unified. Close down the federal courts to plaintiffs, whether it's plaintiffs suing because of police abuse or prison litigation. Class actions have been limited. The real dividing line, I think, between liberals and conservatives in the judiciary today is a question of access to the courts. And again, without simplifying it too much, liberals want to open the doors, give citizens the right to enforce federal statutes, have them act as kind of private attorney generals in the way we do sometimes. And conservatives consistently using one doctrine or another, lack of standing or lack of justiciability or federalism, tend to close the doors. And look what they've done with class actions and arbitration, right? Forcing people to arbitration as opposed to a right to a jury trial. So that's where the battle will be, and right now it's a court that's kind of split right down the middle on that issue. So more than one appointment will make a significant difference, I think.
So what about the other side of access to justice on the criminal side? You were involved in a case here in Pennsylvania Supreme Court addressing the lack of funding for indigent defense services in the state. Can you briefly talk a little bit about that case and the decision and what that means moving forward? I think this might tie in nicely to what we can do at a local level on some of these issues.
Yeah, that's important, and this is kind of local level in the sense of state court system versus federal courts, because state courts have a responsibility for enforcing rights as well. And indeed, over the past, 40 years, as the Supreme Court has become more conservative, a number of civil rights organizations and litigators have gone to state court to try to enforce rights. Sometimes it's federal court, sometimes it's state court. And one good example, this lawsuit that we had and still have against Luzerne County in Pennsylvania. That was the county which you may remember had a huge problem with juvenile justice, where two judges were sent to federal prison for basically being part of a scheme of incarcerating almost every juvenile that came before them, where they had a financial interest in the institutions where they were being sent. It was as bad as that.
Yes.
Well, it wasn't just the juvenile justice part of it. As it turned out, we got a complaint from the head public defender in Luzerne County that his budget was simply so inadequate, he couldn't represent clients properly in that county. We came in, we looked at it, we looked at his office, we looked at his resources, the prosecutor's resources, and thought there really was a huge disparity. And in fact, what was going on was, as we see around the country, a system that some people call meet, greet, and plead. That is, public defenders, because they had so many cases, 300, 400, 500 cases at a time, would meet their client, would greet the client, and then say, here's the plea offer from the prosecutor. You're in jail waiting for trial. You can walk out tomorrow, or you can wait 3 months for trial. We won't be prepared then anyway, because I have too many other cases. What do you want to do? Well, of course, most people say, I'll take the plea. No investigation of the case, no examination of how strong the prosecutor's case is. Often without discovery from the prosecutor. You don't even know how, what the prosecutor's case may amount to. And it wasn't just Luzerne County. It's a problem nationwide in terms of funding the Gideon Promise that we're all so proud of. Everybody's got a right to a lawyer, but how effective will that lawyer be? So we brought a suit in state court in Pennsylvania, challenging that. And just this past year, the state Supreme Court came down really with a landmark ruling, saying that even before a trial begins, and this was the public defender in that county bringing the lawsuit, the defender or a client can bring a lawsuit if they can show systemic flaws in the way that county funds its defender operation, serious enough for a court to say it's predictable that a large number of people won't get effective assistance of counsel as they're entitled to under the Sixth Amendment. You're entitled to something more than a warm body, right? As you know, sitting at a table, you've done public defender work, and you know how important that principle is. So they very important ruling, joining several other states which have ruled the same way, which means that county now will go back to that county for a trial. And now we have the door open and this is access to the courts to try to prove that the funding is so minimal that systemically we know a lot of people, some innocent, others who still may be guilty, are not getting fair representation in their cases. Hopefully, the other thing in Pennsylvania, we are the only state in the country, 1 out of 50, in which there's no state funding for criminal justice. Each county is on its own. And so a poor county like Luzerne County, a lot of poor counties in Pennsylvania, the easiest budget to cut is the defender budget. I mean, they've got no political constituency, right? They've got other issues on their budget. So it's just easy to cut that and thinking, well, no one will really care. Maybe this will help change the political dynamics in Pennsylvania. Maybe we'll get some state funding if enough counties see this as a problem. But more important, it gives public defenders and their clients some access to the courts, as you say, in a local system. We don't have to go to federal court. We can actually go to state court. We've got a state Supreme Court now, which is at least open to these arguments. So,
are there any other bright spots that, for those who are hoping for a more robust civil rights structure in this country, are there any bright spots that we can look to in the next 4 years?
Well, I think the fact that people have, over the past 4 to 8 years, become energized and focused on issues of mass incarcerations, on issues of police misconduct, on the significance of voting rights and not losing them. I think we'll see more now on abortion rights as well, right? If you see what some of the states are doing, Ohio as an example. Those are people's movements. And I think if there's a bright spot, those people will continue to fight. They'll find a way to fight on the local level. This administration will make mistakes, for sure, along the way, even if they become very resistant, to individual rights. So there are still doors open. This is not going to close all the doors that people have to change and to progress. The sad thing is it's going to certainly slow things down and make it more difficult.
Well, thank you for this interesting conversation.
Right. Great to be here.
And thank you for joining us in Case in Point.